Welcome to Case by Case. This is a podcast brought to you by Zalafod Zadkovic in the absence of Luke Zadkovic this week, with Calum Chain and Philip Vagin.
Hi everyone, and thank you very much for the invitation again, Calum.
This is now fourth time on the pod?
I
think so. Yeah. Well, you are always more than welcome, and we have a very interesting case for you to be talking through today. This is a US decision all around the vacation of arbitration awards. The parties are Corporacion AIC as the plaintiff-appellant and Hidroelectrica Santa Rita as the defendant. An interesting one.
Yeah, these Spanish names, they, do give you a hard time to pronounce them properly, right?
I should have let you do it because I know you speak significantly better Spanish than I do. So
no, we should have asked Luke to do it, actually.
Yeah.
So that's a really interesting appellate decision from the 11th Circuit. That's where Florida, I suppose Alabama and Georgia are located in the US. And it discusses a very, very interesting topic about which standards apply when a party to an arbitration seated in Miami wants to set it aside or vacate it. That's the proper term under US law, whether that's governed by the US domestic statute called the Federal Arbitration Act, Chapter 1, or whether the grounds set out in the New York Convention apply here. And the decision contains a very, very illuminating discussion of how basic arbitration concepts work in the US. And then the judges decide essentially to overrule several long-established decisions that the 11th Circuit has itself issued before, which is not something that you see very often, especially if you have one Court of Appeals sitting en banc, which means every single judge working at the 11th Circuit sat on that case and decided it, and they choose to overrule essentially two decisions that their predecessors have issued, starting from 1998, and then there was a second case called Inversiones from 2019, I suppose. So yeah, it's not every day that you see judgments making such a U-turn in the US.
This is also quite unusual from an English law perspective, because the way that English law treats the this kind of annulment vacation of arbitration awards is different to the US approach. So we're looking at this is quite an interesting issue when it comes to forum selection for your arbitration agreements, because it is instructive that in the US, if you choose a US seated arbitration, then they may look at it differently than they would in England. And the second point I want to just pick up with is, so this is overturning previous 11th Circuit judgment. But if I understand correctly, the 11th Circuit was a bit of an outlier among the other circuits in the US. So in some ways it's kind of controversial, and it's overturning a lot of established law, but in other ways it's kind of bringing US law, a bit of maybe homogeneity to the US approach to arbitration.
Yeah, I think that's one way to look at it. And that's the thing about how litigation in the US works and how the judicial system in the States functions. On many issues, including on this one, you can have circuit splits where circuits in different locations take diametrically opposing views on one and the same issue. And here it did look like the 11th Circuit was indeed an outlier. Some can say a more pro-arbitration outlier, because before this decision in Hidroelectrica, they applied the New York Convention and apparently the more restrictive grounds for setting aside or vacating the award to arbitrations that were seated in the 11th Circuit, and the majority of other courts of appeal in the US, they thought and still think that it's the Federal Arbitration Act that provides the exclusive grounds for challenging the award. I think it's you have raised a very important point as a start about the difference between how arbitral awards function in England and in the States. Some of our listeners may know that essentially in England, you have a twofold distinction, right? You have awards issued by an English tribunal seated in England, and that would be an English award. And there are foreign awards which a party takes to England to recognise and enforce them, and they would just be that foreign, not English. In the US, the situation is a bit more complicated because you have a distinction between three types of award. You have what's called a domestic arbitral award. That's from an arbitration seated in the US between US parties. And Chapter 1 of the Federal Arbitration Act applies to these and says that it's Chapter 1 that governs setting aside or vacating.
Two US entities arbitrating a dispute with an arbitral seat in a US state.
Essentially, these are called domestic because there's a non-domestic element here, right? It's all very much connected to the US. Then you have the non-domestic awards, where the arbitration is still seated someplace in the US, for instance, in Miami, but the parties, one of the parties, is not from the States. And that's exactly the situation where, like in this case, for instance, you can have a Guatemalan company arbitrating against another Guatemalan company, and that would be a non-domestic arbitral award that results from these proceedings. And lastly, you have foreign awards. These come from arbitrations that aren't seated, that aren't located in the US, and one party takes the award to the US, for instance, because there might be assets here owned by the debtor, and that party wants to recognize and enforce the award in the US. Yeah. So you can see how different jurisdictions can take different approaches to how they structure enforcement, recognition, and vacating awards.
There's a slight difference between. Well, there is obviously a significant difference between enforcing an award and vacating one. But here, I suppose fundamentally is the question of does the court have the power to vacate this award? And obviously, it's an arbitration seated in Florida, so the 11th Circuit does have some kind of supervisory jurisdiction, and then the question is what rule should it follow in exercising that jurisdiction?
That's also, I guess, another bit of terminology here. Sometimes, and in the judgment as well, you see this distinction between primary and secondary jurisdiction. Typically, what they call in the US primary jurisdiction is referring to a court which sits in the location of the underlying arbitration. So, for instance, the Southern District of Florida federal court sitting there would be the primary jurisdiction for trying to vacate or challenge or annul the award rendered in an arbitration seated in Florida. And you also have what's called secondary jurisdiction, where the court that reviews the award at the enforcement or recognition stage does that, but it's not the court that was located at the seat. So, and that's the distinction which the judgment in Hidroelectrica dwells on quite a bit.
So, should we, before we get into the points around the specific arbitration, the specific law of the application of these laws to arbitration seated in the 11th Circuit. This is some kind of preliminary point. So this was a decision that was handed down on the 13th of April of this year. So it's a recent one, reasonably hot off the press. The file number is 20-13039, and the citation is 2023 WL 2922297. For those who are interested in the citations. And I know the point here is to a large extent besides the point of what this judgment is looking at. But the background to the case is that you have these two companies. One has agreed to build a hydroelectric power plant for the other. There was a dispute around force majeure, and there was an award saying that there had to be the return of certain advance payments. I think that broadly covers. Yeah.
I don't think that the particular facts of the underlying dispute that went to arbitration in Miami are super relevant to the discussion and the judgment. But yeah, it's a scenario that you see quite often in these large international arbitrations. You call it a construction project, something goes wrong, the party sues to return the prepayments. And in this case, it was the unsuccessful party, the contractor, that applied to the Southern District of Florida Federal Court to vacate the award, saying that the arbitrators exceeded their powers. And that's the language that is not found in the New York Convention. Excess of powers. This is something from Chapter 1 of the Federal Arbitration Act.
This is essentially an attempt by the unsuccessful party. They say, we actually want this whole decision. We're not appealing the decision. We're saying the decision is there, but the tribunal in making this finding has exceeded their powers. And what we would like is for the decision, therefore, to be set aside or to be vacated.
Vacated.
Yeah. And the reason that the fact that they've used this reason of the tribunal exceeding its powers means that their claim kind of by definition lives or dies on, if let's assume they succeed and they're right that the tribunal has exceeded its powers, then if you go under the American legislation, the FAA, then that challenge to the tribunal and the tribunal's award will succeed. But if you go under the New York Convention, that challenge will fail.
It's one of these questions about substance over form, really, because how the different standards would have applied in this case, I don't think would have made an eventual difference to the outcome, right? So here, the unsuccessful party, when they tried to vacate the award, they chose to rely on the Federal Arbitration Act, Chapter 1, saying excess of powers. But I think in this situation, they could have tried arguing, likewise, under the New York Convention, that the tribunal did not have jurisdiction to decide a particular issue. So they could have tried to fit this into a New York Convention ground, but for some reason the unsuccessful party wanted to rely more on the Federal Arbitration Act, Chapter 1, maybe because they found favorable local case law saying that in a situation like that, you can try to proceed under the FAA as opposed to the New York Convention. Maybe that was from a different state or a different circuit. But yeah, so what happened after that in terms of procedural posture is that the Southern District of Florida said that they can't rely, I suppose, on the grounds in Chapter 1 of the FAA because the vacature or the annulment of awards is governed exclusively by the New York Convention in the 11th Circuit, and that was the position from the 1998 decision in a case called Industrial Risk. So the other side that lost in the Southern District, they appealed to the appellate court, to the 11th Circuit, and a 3-panel judge, it had to affirm the decision below. But you can see how they were very dissatisfied with that outcome, because I think when affirming the decision, the 3-panel, the 3-judge panel also said, well, we are only doing so because we must follow the precedent set by these previous decisions, but we would very much like for that to be overturned. And so could you please go to a full bench on bank of all the judges sitting in the 11th Circuit so that we could reconsider, because the way sort of the rules of precedent work in the States, it's only a full bench of, I think that was 10 or 11 judges that could overturn a previous circuit decision. And that's what happened in this case.
Right. So they got the whole band together to try and fix this issue. And going back to your initial distinction between domestic awards, non-domestic awards, and foreign awards, the kind of sliding scale of whether you use domestic U.S. legislation or the New York Convention when you're considering those awards, it's clear that in the domestic context you're under the FAA. Under the foreign awards, you're looking at it through the prism of the New York Convention. and really it's this middle ground where you have to work out what's the correct answer. Do you know if there are, obviously in this decision now, the 11th Circuit joins the majority of the US in saying that the FAA is the right place to be looking for you grounds of vacatur. Are you aware of any other circuits that still apply New York Convention to this question?
To be honest, I don't. I think this is now the majority position. There might still be some lower level courts at the district court level that think that the New York Convention should govern in a situation where you have a non-domestic arbitral award, but the 11th Circuit seemed to be like the largest outlier here.
I suppose the question is why? So the court then goes through and says, right, we think the FAA applies here. Effectively the court says we're going to apply our own law. We're going to say US law applies to this US law. Attempt to vacate the agreement. But for you, what are the key reasons why?
Well, I suppose the big part of the discussion in the judgment, it's centered around what the New York Convention, sort of in a vacuum, in abstract, does and does not apply to. You can see how the bench takes you article by article through each provision of the New York Convention, and they conclude, well, with a fairly obvious conclusion, right, that the New York Convention does not deal with setting aside or annulment of arbitral awards rendered at the seat of the arbitration. Initially, it was designed to harmonize rules relating to enforcement of arbitration agreements and also to recognition and enforcement of foreign arbitral awards. So that's basically how the convention applies if you don't attempt to modify it or play around with it in your own national domestic legislation.
And this is where we start to talk about setting aside arbitration awards under the New York Convention. I think we're looking at Article 6 of the New York Convention, which talks about setting aside arbitration awards. But really, what we're saying here is that where the New York Convention is considering setting aside arbitration awards, it is not considering how the law of the seat of the arbitration treats the validity of an award. It's more about if you take an award into a third country with a view to enforcing it, how that third country is going to deal with the request to enforce this arbitration award.
Yeah, essentially. And the judgment, it does draw the distinction between defenses to recognition and enforcement, which is what, for instance, the debtor can say to the creditor who takes the award to a country like the US and tries to recognize and enforce it. For instance, they can rely on grounds in the New York Convention, like lack of capacity, or the fact that the arbitration agreement was not valid, or that the dispute is incapable of being submitted to arbitration. Those would be proper defenses, i.e. the debtor saying the award should not be recognized. But there's also a separate category of grounds for setting aside or grounds for annulment of arbitral awards. And in conclusion, what the court in Hidroelectrica found is that because of this distinction between recognition and enforcement that's governed by the New York Convention and setting aside of an award that was rendered in the United States, one cannot just look at what the convention says and apply that domestically. So this is not to say that, the reasoning that the 11th Circuit employed was, impeccable or not susceptible to criticism, but it does appear to have like a sound foundation. Even if the US incorporated the New York Convention in their own domestic law, it's going to be a leap from that to say that the convention now applies to awards issued within the US.
This was part of the decision. I think what the court was saying is, look, it's possible for a jurisdiction which is a signatory to the New York Convention to extend the application of the New York Convention to be the mechanism by which that country deals with setting aside awards where the court is the court which is has that supervisory jurisdiction over where the arbitration is seated. You can do it. You can write into your local law, we apply the rules of setting aside judgments in the New York Convention to setting aside or to as part of our kind of challenging arbitration awards legislation. And the question was whether the relevant US law did that. And they looked in quite a lot of detail at the a few of the key provisions in the FAA. And there was one where they were, they really influenced by the use of this word confirm. There was a part of this provision says the court shall confirm the award unless it finds one of the grounds for refusal or deferral of recognition or enforcement of the award specified in the said convention, being the New York Convention, and the party that was seeking to say that the New York Convention should apply and should be the governing should govern whether or not this award is vacated. They said, well, that clearly tries to bring in the New York Convention into our local law. And the other side said, no, what you're talking about there is a confirmation of the award. So this is actually doing exactly what the New York Convention is supposed to do. Its normal purpose of the court determining with a foreign award, i.e. an arbitration seated outside of the US, should we be confirming this award or should we be setting it aside under the New York Convention? It doesn't go far enough to say that it would apply to these non-domestic awards.
Yeah, that was one of the disputes that was had in the underlying litigation and one of the arguments that the 11th Circuit considered. And to be fair, at least to my mind, this entire question on appeal, it turned not necessarily on the scope of the New York Convention or what the convention tells us, but rather on whether the US extended the ambit of the convention to say that not only does it apply to arbitration agreements and recognition and enforcement of foreign awards, but also have we modified it so that it also governs vacating or annulling awards rendered in the US. And I mean, it's a possible scenario, right? I'm pretty sure that there are jurisdictions that have made that choice, for instance, because they want to seem more arbitration friendly, of extending the New York Convention to apply even to awards rendered domestically. It has the certain attraction of making more clearer, and instead of receiving advice on different sets of rules governing challenges to awards and in governing recognition and enforcement, a party can be sure that more or less the same standard of treatment would apply in either situation. And I mean, the judgment from the 11th Circuit, it does give some credence to that view. It says, that there is a public policy, sort of pro-arbitration view that keeping things as they are in the 11th Circuit, where the New York Convention applied, would have been a more arbitration-friendly outcome. But they say, well, this is not really borne out by how we read Chapter 2 of the Arbitration Act. I think I should have said at the outset, the FAA, it's got two chapters. Chapter 1 applies to domestic arbitrations primarily, and it also applies to non-domestic arbitrations where there are gaps. And, a big part of the court's reasoning was, well, Chapter 2 incorporates the New York Convention into US law, but the convention itself doesn't deal with vacating or setting aside the awards. So where should we look to? We should look to the gap-filling provisions, the default provisions that are in the Chapter 1 of the FAA. And I think it's also helpful if we just read out what are the grounds for vacating the awards under the FAA. I mean, I'd assume that most listeners are familiar with what the New York Convention says about, lack of capacity, lack of a valid arbitration agreement, improper constitution of the tribunal, etc. But just to appreciate the difference between these grounds, in the FAA, it's if the award is procured by corruption, fraud, undue means, where there was evident partiality or corruption in the arbitrators, where the arbitrators were, interestingly, guilty of misconduct in refusing to postpone the hearing on sufficient cause shown, or in refusing to hear evidence pertinent or material to the controversy, or any other misbehavior affecting the rights of the parties, and the ground that was invoked in our case, the excess of powers, or where the arbitrators so imperfectly executed them that a final award was not made, essentially. So these are the statutory grounds. I don't think we should be losing track of another feature of how US arbitration law applies. There are also several non-statutory grounds that apply in the US. The most famous one of them being the manifest disregard of the law, where the tribunal or the panel willingly does not pay attention to the governing law. For instance, they just disregard a time bar or apply a different governing law where their error is just so obvious that the award should be set aside. This is something that's not written in the Federal Arbitration Act in Chapter 1. This is something that the US Supreme Court essentially invented in the 1950s, and that decision from the US Supreme Court was later cited with approval by the court and by lower tribunals. So this is just to illustrate that there might be a difference between the grounds in the New York Convention and in the Federal Arbitration Act. Even though many of them would overlap, I'm pretty sure that there might be a case where the outcome would depend on which set of rules actually apply.
So what I struggle with about the way the law was in the 11th Circuit before this decision is that it puts this big difference between domestic and non-domestic arbitration. And conceptually, I struggle with why there would be a difference. If you have two parties who have agreed to have an arbitration seated in Miami, then why does it matter where those two companies are based themselves in terms of the law that we apply to how the Miami seated arbitration functions and the amount of weight we put into the award that tribunal gives at the end of the process? I struggle to see why it would make a substantial difference to how those things are treated if the parties were based in the US or the parties were based outside of the US.
That's also one of the arguments that the court in the 11th Circuit deploys, and it says, well, why should we be giving this preferential treatment in terms of setting aside awards to international disputes?
So say for example, you're a US entity, but you've also got a branch office in the UK, or you have a subsidiary in the UK. If the law was that there was a different enforcement regime a different regime around vacatur for US-based companies, then could you just assign out your claim to the UK entity? The UK entity brings the claim, and then you get the preferable arbitration regime in your US arbitration.
Well, I suppose one would need to show that assignment was done specifically in order to circumvent that, less preferable regime for domestic arbitrations. But I can totally see arguments from a sort of pro-arbitration and public policy perspective that a country can introduce a more relaxed set of rules to make international and foreign parties come over and arbitrate more. And you sometimes see that in jurisdictions which didn't used to be, great hubs for international arbitrations, and they would say specifically, in order for you to come and arbitrate in our country more, we are introducing this new set of rules which will make an award rendered in these proceedings between foreign parties harder to challenge. But here again, in the US, it all came down to whether the US legislation, the Federal Arbitration Act, actually achieved that purpose. And the 11th Circuit, they weren't convinced that the words that we have quoted, I think that's 9 USC 207, speaking about confirmation of the award, unless a court finds one of the grounds for refusing recognition, they didn't think that meant that the US opted for a more sort of pro-arbitration approach for non-domestic arbitrations. And I mean, going back to one of the points with which we started, I guess what's the practical difference, or what's the practical outcome here? It used to apply one standard, now there's the other. I'd be really interested in seeing some empirical research done, just to compare the percentage of vacatur applications, or applications to annul or set aside awards after this decision and before. Because if it is correct that there are actually differences between the FAA grounds and the New York Convention grounds, you would see an increase.
It will be interesting to see, I wonder if someone will do that study. As you say, it should. If it follows that if it's been made easier to set aside awards, then more will be set aside. But it's a very interesting one, and I think I suppose the key takeaway really is if you're in a US seated arbitration with foreign parties, i.e. non-US parties, then if you want to set aside that award under US law or vacate that award under US law, then you're likely looking at the application of US legislation rather than the New York Convention.
There's an argument to say that would also be a predictable outcome, right? If you have the majority of the federal circuits, like the Second Circuit in New York, for instance, already applying the Federal Arbitration Act, well, you shouldn't be surprised if you were to arbitrate in Miami, which is a big international arbitration center, that your award will also be governed by the same standards, that there shouldn't be some sort of preferential treatment here. To my mind, this was more of a statutory interpretation case, right? Mm. Because the panel, it didn't sound from the judgment as if they, wanted to achieve a particular outcome, or that, they already had this pro or against arbitration mindset. They were just more interested in seeing whether the language of the Federal Arbitration Act, and especially Chapter 2, which deals with the incorporation of the New York Convention, could be read to mean that the convention also applied to US-seated awards. Yeah. And, they just weren't persuaded that that was the case. I don't think, there's much grounds for people to say that, this is an anti-arbitration decision. I've seen some sort of reports about this case to suggest that, this is against international arbitration. I don't think that the practical outcome will be very significant, although this is all subject to someone actually looking at the data and seeing whether the number of challenges to awards seated in Miami increases.
But I find it unsurprising that basically this is a decision where the court decides to apply its own law. There's nuance to that, and really what they're doing is they are in any event applying their own law, and they're saying whether how should we interpret our law? Does our law pull in the New York Convention rules, or does it have something else? And I appreciate all those nuances, but fundamentally what they're doing is they're saying we have laws about when an arbitration is set aside, we're going to apply them. And I think that it's from an English law perspective, at least, that's a very straightforward and sensible way of looking at it.
Yeah, I suppose that's how the decision lands. They just weren't persuaded that the particular wording of the statute here, made this carve out for arbitrations involving international parties, and that the Federal Arbitration Act didn't really give that much preferential treatment to such non-domestic arbitrations.
Well, it's a fascinating decision. Thank you, Philip, again for joining us.
Yeah, well, thanks for the invitation.
And I think next week we will have Luke back in the hot seat. So looking forward to that. But it's been a fun one. It's always interesting speaking through US law with you, because obviously you've got your US law ticket. So the differences between the way that the US approaches some of these concepts and the UK is very. It always surprises me how much subtle difference there is between US law and English law. Similar, broadly speaking, similar legal outcomes to the same sorts of disputes, but these process points are all often quite distinct.
Yeah, the devil's in the details.
Exactly. Super. Thank you, Philip. Thank you, everybody, for listening. Please do like, subscribe, follow, all the usual things wherever you tend to listen to these things. We are often blown away by the support that we have for people listening in. So we really do appreciate it. We appreciate the comments. We appreciate the feedback when we see you in person or through email. So please do keep all that coming in. And thank you, Philip. Thank you, everybody.